Hey everybody. So I don't know if anybody's gonna come into this live or not. But I just wanted to go over the court documents and give you my opinion of them, tell you what I think they say, and then tell you whether or not it changed my mind or if it would have changed my mind if I would have known it from the beginning. So let's just jump on into it. So we're going to go through all of the documents, or at least most of them anyway. But this one, if you ask me what it's saying, this is the defendant's exhibit 4B, which will be referenced later on in some of the court documents. It says talking about knowing one of their dads. I can't make out this word right here. And then it says walk with them. One of them wanted to turn around, grabbed youngest shoulder. It's okay. Oldest freaked out, got paranoid, and grabbed her. One said something about calling police. Sexual attack wasn't something originally. Wasn't the plan maybe originally. Not trying to go are them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. So then this is page 2 of Exhibit 4B. He started talking ironic, should have been in school. Talking to them, knew one of their moms worked at a bar. Animals, walked with them, willing to check out horses. And he says he told them he had rabbits in the barn. Walked through trail in the woods. Oldest paranoid, didn't want to go. Youngest wanted to see horses. Oldest tried to help youngest. Oldest started looking maybe. Youngest scared. Can't make out that. He now grabs oldest. He said he got hit on nose. Scared he got blood. One of the girls pulled box cutter out, slit oldest, and hit an artery. Youngest scared, etc. Took little girl with him for a while. Never said where. He said he cut her to cut both necks. He left again, came back. That maybe came back. Not sure what this word is here. In the evening, search going on. Later on, not sure what this says here. Not sure what that says. not going to be found. Place where four-wheelers something go. Burned his clothes in burn pile. Hiking boots, gloves. Not sure what this word is either. Bag, maybe. Could soles of boots be located in burn pile? Next morning, two other girls knocked on the door, asked to search on property. Felt weird if he said no. He let them take off, got a hold of family member, and got out of area. First something. He first time he's seen them from property. I'm not sure what this part here says. Inner, etc. Guns, maybe. Um, During the struggle, youngest girl screamed, maybe. Um, I cannot make out any of that really right there. Um, Something in the neck. I want to say injury, but I'm not sure right there. I know later on they say artery, but that doesn't look like artery to me. I'm not sure what this whole page is. With numbers. It might tell us here in a minute. So what gets me with this is, this was supposedly made, this confession from Ron Logan was supposedly made within months of the girls being unalived, right? But I have followed this case for pretty much from the beginning, like day one. And I don't ever remember any of, it being a box cutter or their necks being cut. Any of that being public. So if this is being said a couple months, 2-3 months after the girls' lives were taken, to me, it has a lot of things in there that people wouldn't have known. Like the normal public wouldn't have known. Would family have known? Yeah. Would the killer have known? Hell yeah, they would have, right? But as for the normal public, we wouldn't have known, right? We weren't told. That was kept close to the vest. It wasn't discussed. It was something that law enforcement wanted to keep kind of quiet, basically, because the person who unalived the girls would know this information. So if Ron Logan really did say this, then that's a big red flag to me. Because if you want to take Richard Allen's confession after he was in prison for months and in solitary confinement for months, then why wasn't this taken? Did law enforcement drop the ball? We already know that law enforcement dropped the ball, because law enforcement did not look into Richard Allen any further, even though he admitted to being on the trails that day. He admitted to being in the clothes that Bridge Guy was wearing. You know, did they drop the ball? Is this just another example of Carroll County, Indiana State Police, whoever was head over this, did they drop the ball? And I think they did. So let's just keep going, and then we'll talk a little bit more about it. It says 3 months from something. Parole, maybe. He got here 2 months in 4-pod dorm. Originally, something line together. Reunited to set up. JPay account helped him with that. Started talking uncomfortable circumstances, protective custody, talking about it at the beginning, modifying county charges, etc., talking, walking, something. First made comment, losing. I can't make out this word here. Film footage, etc., that don't look like me. Started talking to Bunky. So the way I take this is that he was talking to him, and at first he was uncomfortable. They were in protective custody, so they were bunkies, and they were just basically, he was chatting him up about it. But what gets me is he talks about film footage, etc., that doesn't look like me. So by this time, the footage of Bridge Guy was out there, right? We all know the footage that we've seen of the grainy person on the bridge. Now, Richard Allen said he was on the bridge. Richard Allen said he was wearing what Bridge Guy was wearing. Is it possible, and I'm playing devil's advocate here, is it possible that Richard Allen turned around and Ron Logan intercepted them at that point? I know it's a tight time frame. I know this. Like, I fully believe Richard Allen was Bridge Guy because he said that's what he was wearing. But then tell me how Ron Logan knows all these specific details and why he's saying that there's film footage, etc., that don't look like me. Like, to me, that makes me start to question whether or not Ron Logan really could be in this. And I've said from the beginning, I thought there were 2 people. Then they came out and said there was 1 and that it was Bridge Guy. You know, did Abby and Libby come across 2 killers that day? Were they followed across the bridge by 1 killer and met at the other end by another one? Like, and then 1 got scared and ran off? Or did they both participate in this crime? Like, there are so many questions that this brings up in my mind. Like, it doesn't, so far hasn't changed my mind whether or not Richard Allen is guilty, because I fully believe he is. By his own words. And I'm not talking by his confessions. I am talking by the fact that he said he was on the bridge that day at that time in those clothes, and that's what Libby recorded on her phone, right? Like, that's where I'm at with Richard Allen. I personally don't necessarily believe his confessions, but that's also because he said in one of the confessions that he would never cheat on a cigarette again because he killed Abby and Libby. Like, really, that makes no sense. Did he do it? I don't know. Like, I don't know. At this point, I don't know. I think he did. But I also think that when Judge Gull said there was no nexus for any third-party evidence to come in, like, this was all in discovery, and we'll get to that in a minute. But, like, you guys had this defense team. Why didn't you use it? Like, why didn't you fight? Like, why didn't you say, well, here's the nexus. He knows things. Like, if you're going to take Richard Allen's confession about a white van, and that's what makes you believe his confession, right? Then why don't you believe the confession of a man whose property they were found on, right? Who had access, clearly, who lied about where he was going before the girls were found, said to a family member or a friend that he needed an alibi for that day, right? Like, all of these things, and then knows how the murders happened. Like, to me, you've got more on Ron Logan than you did on Richard Allen. You got Richard Allen in the same clothes. You've got Richard Allen on the bridge. I get that. But you got Ron Logan knowing things and saying things months, like 3 months after the girls were killed, that only the killer would have known. With what tool? What happened? What was said? Like, this is an awful detailed thing for somebody to be making up. And I don't think somebody could make it up, this Ricky guy, with this much detail that's accurate, that matches the crime scene. Like, that's what bothers me. So let's keep reading. We got a lot of documents to get through. So, two different scenarios. Drinking on probation. That day, he came home and he went out. He said he seen girl get two different teenagers. Not sure what that word there says. Shook up, walked something, came back from rabbits, chasing wild rabbits, squirrels. And I'm assuming that means that it's the first scenario, right? So this is to certify that on or before January 20th, 2025, the foregoing defendant's Exhibit 4B was served on all counsel of record by the court's electronic filing system, electronically signed by Andrew Baldwin. So this is the defendant's Exhibit 4C, signed by Ricky Davis on 6/21/17. So this is the note. And so for me, it says that let me make this bigger. Mr. Logan has spoke referring to the killings in Delphi, Indiana. He told me he was the one who killed those girls, that it got out of hand, He walked them in the woods to his property, which, I mean, I guess you could have got to his property through the woods, but you still would have had to cross the river, and that was left out. The girls wanted to turn back. One said something about calling the police. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. Oops, too big. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was taken too far. And then he signed it. So again, February 13th. So this is, I think that says 6. So 4 months, just over 4 months after the girls were killed, he wrote this letter. Well, how did he know? Like, this is awful specific. How did he know it was a box cutter? How did he know that the girls were cut? Like, it doesn't make any sense that if he's making this up, that he would have that kind of detail. And keep in mind, this is what he is saying that Ron Logan told him. So it's like hearsay of hearsay, maybe. I don't know how that would be put. Third-handed hearsay. So that is just showing you. I had transcribed this beforehand because it was going to be too much to try to make out. So this is to certify that on or before January 20th, 2025, the foregoing defendants Exhibit 4C was served on all counsel of record by the court's electronic filing system, electronically signed by Andrew Baldwin. Look at that ugly mug. Okay, so defendants 3E. This just talks about Brad Weber. It says at 2:02 p.m. time card leaving the Subaru Indiana Automotive on February 13th, 2017. Weber's phone pings to parents' house address overlooking the crime scene initially at 2:50 and reportedly pings around the property until 11:55 p.m. And then it says, did anybody else reside at the Weber home? And this just certifies again by Andrew Baldwin that this was sent by the court's electronic filing system to all the parties. So this is Exhibit 1, Kathy Allen's affidavit. The affidavit, I can't talk. The affiant Kathy Allen, upon her oath, under penalty of perjury, says that she is Richard Allen's wife. And on October 26, 2022, my husband was interrogated, arrested, and jailed. The next day, October 27, 2022, I paid Brett Gibson, a lawyer in Lafayette, Indiana, $5,000 to represent my husband. Exhibit 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. The evening of October 27, 2022, Mr. Gibson sent a letter by email to the Carroll County Sheriff and Nicholas McClelland, the Carroll County prosecutor, telling them he was representing my husband and they should cease all questioning of him. Exhibit 1B is a copy of that letter sent to me by Mr. Gibson. About 10 p.m., Mr. Gibson called me to say he would not be able to get my husband out of jail because he was going to be charged with, you know what, the next day. The affiant says nothing more. Signed, Kathy Allen, January 19th, 2025. That's just another certificate saying, hey, we sent this to who we need to send it to. Signed by Andrew Baldwin. So this is the email through Outlook. Of course, they've redacted email and all that. Showing a payment of $5,000 to the Gibson Law Office with her Visa card. They really should have redacted that as well. I know it's redacted, but still. So he had representation. So why were they still questioning him? Like, why weren't they going through his lawyer? That's not right. That's a violation. So this is just stating that Exhibit 1A was served again. So this is Exhibit 3, which is the affidavit of Matthew Hoffman. The affiant Matthew Hoffman, upon his oath under penalty of perjury, says that he's an investigator who worked for the lawyers representing Richard Allen. Included in the discovery. So that to me is important, right? And we'll get back to why here in a minute, but it says included in the discovery provided by the state is a video file being filed with Mr. Allen's verified motion to correct error in the defendant's Exhibit 3A. Exhibit 3A is a video recording made by a security camera that was in the house at 5998 West County Road. The house circled in the Google map. Right here. Right? The video recording was made on February 13th, 2017. The video recording was collected by law enforcement as part of its investigation into this case. The video recording was provided to the defense by the state of Indiana, has therefore been in the state's possession. The original file name of the video recording as it was received by the defense is, and then it gives it out. I'm not going to read all that. The video recording Exhibit 3A is being filed with the file name. Again, the security camera faced west-northwest. The security camera recorded continuously. The security camera was set to record with date and time information as part of the recording. The time on the security system was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. So how do they know that? Like, is that what the homeowner told them? Is that something they somehow verified? Like, I'm not sure how they got that part. I'm going to assume that's what the homeowner told them. The security camera recording that is Exhibit 3A covers the time from 2:42:06 to 2:50:32 on February 13th, 2017. The security camera had a wide-angle lens that captured video traffic on West 252 North in the beginning of the private drive to the Weber property, which is indicated by the end of the arrow in the Google Earth map below. So, right here. And the beginning of the private drive to the Weber property. Yeah. So this right here would be the beginning of the private drive. 190 feet north of the road's intersection. So county roads north county roads north 625 west and west 252 north are the only roads by which the vehicle could enter the Weber property. Any vehicle entering the Weber property by road would have been recorded by the security camera in that house. I reviewed Exhibit 3A. According to the time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on, I'm not saying that again, north 625 west, entering the frame at approximately 2:44:33 on February 13th, 2017. Keep in mind that 2:44:33 is after the girl's phone had already stopped moving. Exhibit 3A also shows a white vehicle continuing into the private drive of the Weber property. Exhibit 3B is a video file that contains 3 zoomed-in clips from the video recording. The video file that is Exhibit 3B is being filed with the file name, and it gives it. Each successive clip in Exhibit 3B is zoomed to greater magnification. I reviewed Exhibit 3B, and it shows all 3 zoomed clips: a white cargo van going north after 2:44:33 p.m. on February 13th, 2017. Exhibit 3C is a PDF with all the photographs taken from Exhibit 3B at each magnification level. For each magnification level, zoom 1, zoom 2, zoom 3, there are 3 stills showing a white cargo van just before it passes the white sunlit house in the background on the west side, 2 as it blocks the sunlight house, and 3 after it has passed the sunlit house. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state, and therefore has been in the state's possession. So if it's been in the state's possession, then it should have been in discovery, right? So that means if it's in the state's possession and it's in discovery, that means it's also been in your possession since the beginning of the case, which means you've had time to find this. You had time to bring this up. Like, you had time to use this in court. Why didn't you? The original photograph, as provided to the defense, had the file name, not reading that. I reviewed Exhibit 3D, the photograph of Mr. Weber's white cargo van, and Mr. Weber's van in the photograph appears to be at least similar to the white cargo van as it appears in Exhibits 3B and 3C, the zoomed-in video clips and zoomed-in still photographs created from Exhibit 3A, the original security camera footage recording. I have reviewed the other video files produced by the security camera covering the time from 2 p.m. to 4 p.m. on February 13th. This says 2018, so typo? Because it would have been February 13th, 2017, not 2018. So just like in the Frank's memo, they're starting out with typos. And they do not get any other van driving north into the private drive of the Weber property. Exhibits 3A, B, and C reflect that if Mr. Weber returned home in his white cargo van, he could only have arrived home some minutes between 2:44:54 on February 13th, 2017, 12 minutes after the time the extraction of Libby's phone showed that the phone stopped moving at 2:32. So if the phone stopped moving at 2:32, and that's what time the prosecution said that the girls were unalived, right? But you took Richard Allen's confession saying that he unalived them because he seen the white van, then the girl's phone still would have been moving. So it doesn't add up with the state's timeline. So either the white cargo van shown in Exhibits 3A, B, and C is Mr. Weber's, with him arriving home some minutes after 2:44 on February 13th, 2017, or it is not. Duh. In either event, no white cargo van or any other van entered the private drive to the Weber's property after 2 p.m. and before 2:32 p.m. on February 13th, 2017. The time of the extraction of Libby German's phone shows the telephone stopped moving. Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber and is dated March 3rd, 2017. The unredacted version of Exhibit 3E was provided to the defense by the state and has therefore been in the state's possession. The unredacted version of Exhibit 3E containing Mr. Weber's personal information and photograph was provided to the defense with the file name. I have reviewed the original FBI subject information sheet for Mr. Weber, and the redacted version, Exhibit 3E, is a true copy of the original, except that Mr. Weber's photograph and personal information have been redacted. The FBI subject information sheet for Mr. Weber, Exhibit 3A, says on 2/13/2017, Weber's phone pings to parents' address overlooking the crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. That Mr. Weber's phone first pings to his parents' address at 2:50 on February 13th, 2017 is consistent with the video evidence in Exhibits 3A, B, and C showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:44:54. But again, the phone stopped moving right at 2:32. And then this is just the signature sheet for Matthew Hoffman, signed by Andrew Baldwin. So this is the redacted no. So this is an investigative thread. So this is Exhibit 4A. On 5/15/2017, blah, 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 contacted the FBI Public Access Line Unit to report a tip about the Delphi homicide. So-and-so provided the following information. Ricky Davis, DOC number, is currently incarcerated at the Newcastle Correctional Facility. Gives the address and telephone number. This person received a call from Davis advising he is in the same block as Ron Logan, owner of the land where the Delphi homicide took place. Ginrich, maybe, reported Logan is in prison for parole. So I'm assuming they should have redacted that name right there. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he killed the older girl first. Said Ricky wants nothing from this but justice for the girls. So that means a lot to me. All right. He's not saying, right? He's not saying, hey, I'm going to tell you what I know if you let me out of prison. I'm not telling you what I know if I get some. I'm telling you this because I want justice for the girls. Right? So I just have a hard time with how do I put, like I have a hard time not believing him, right? Because this isn't a I scratch your back, you scratch mine type thing. Um, he's just saying I want justice. So I have a hard time thinking that he's gonna make all this up. Like, I don't know. I have a hard time believing he's making it up. Person of interest, Ron Logan, male. And that's just a closer view of it. Okay, so this is Exhibit 3D. All right. This is to certify that on or before January 25th, 2025, the foregoer defendant's 3D is served by all the counsels. Again, signed by Andrew Baldwin. That is Brad Weber's white van. That's the one that they were saying, right? Okay. So this is the defendant's motion for hearing on motion to correct errors. I don't know how many of these were errors. And I'll explain why as I go along. Give me just a second here, guys. Okay, so the defendant, Richard Allen, by counsel, respectfully requests that this court set a hearing on the defendant's motion to correct errors. In support of his motion, the defendant states the following. The defendant has filed a motion to correct errors contemporaneously with the filing of this motion. In his motion to correct errors, the defendant requests that the matter be set for a hearing. Indiana Trial Rule 7C requires a party requesting a hearing to file such a request by a separate motion. Wherefore, the defendant, Richard Allen, by counsel, now respectfully requests that this court set a hearing on this motion to correct an error and for all other just and proper relief in the premises respectfully submitted by Jennifer Auger, which I always want to say Auger because I don't know. Bradley Weber, or Bradley, Rosie, and Andrew Baldwin. And this is just saying basically that they sent it. So this is the limited appearance. Name of defendant, Richard M. Allen, defense attorney, information. Will defendant accept a fax service? Yes. Additional information required by the state or local rule not applicable. Although defense counsel never withdrew their prior appearances, it appears the court on its own withdrew all defense counsel before the time had transpired for trial counsel to file Mr. Allen's motion to correct errors. This appearance is limited for the purposes of filing Mr. Allen's motion to correct errors, motion to preserve specific evidence, and motion to correct abstract judgment. And then again, just saying that they filed it. So this is the motion to correct abstract of judgment. Defendant Richard M. Allen, by counsel, requests that his court that this court issue an amended abstract judgment in support of this motion. Defendant states the following. On December 23rd, 2024, this court issued an abstract judgment in this case. Under Part 4 of the form, the court indicated that there were no mental health concerns with the defendant. Yet at trial, evidence was presented and the defendant had significant mental health concerns throughout this case. Dr. Walla, Dr. Martin, Dr. Westcott all testified about the defendant's mental health issues. Video evidence revealed behavior by the defendant while awaiting trial that raised concerns about his mental health as well. Providing accurate information on this abstract judgment is critical to ensure the DOC is aware of the defendant's mental health issues so that the defendant will receive continuity of care and appropriate placement, effective treatment, and medication. Wherefore, defendant by counsel respectfully requests that this court issue an amended abstract judgment reflecting the change in the answer under mental health concern from no to yes. The defendant additionally requests that this court forward a copy of this amended abstract judgment to the Indiana Department of Correction. And I don't blame him there. Like, the man's got documented issues, right? And it was throughout trial, you know, they've got video of it. Like, even if he was faking it, like, you got to be crazy to fake it to the point that he did. And he had mental health issues beforehand. So I agree here. They need to change it to yes. Yes, he has mental health issues. Yes, he needs to be seen. So this is defendant Richard Allen's verified motion to correct errors. Comes now the defendant Richard Allen by counsel and files his verified motion to correct errors. For the reasons that follows, the court should either vacate Mr. Allen's convictions and or set the matter set out below for hearing. I don't think he's got much of a chance for that, being as its goal, but you never know. So in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding of November 3rd, 2022. Mr. Allen was entitled to be represented by counsel, and under the United States versus Chronic of 1984 and its progeny, I'm not sure what that word is, the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. So some of this I'm not going to read through because I just don't feel like it, and I don't feel like it's worth taking the time to, but you can pause it there and read it all you want. So basically, the inmate in county jail was awaiting trial, is in danger of serious bodily injury or death, and that's why they did the safekeeping order. But then they came out later and said that there was no actual threat against him. So how did they get the safekeeping then? If there was no threat against him, if there was no legitimate threat, if there was nobody saying that they were going to go hurt him, then how did they get the safekeeping? Like, that doesn't make any sense to me. Indiana Code also governs safekeeping proceedings for pretrial detainees and provides in full. Basically, he had the right to say before, either at the hearing or post transfer, that he didn't want to. He didn't want to be protected, basically. The inmate or the receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. And that was their only issue. from my understanding of it. That was their only issue, was his personal safety, whether or not somebody was going to hurt him. So he had the right, under this Indiana code, to say, no, I don't care. I still want to be in county jail. I don't care. I don't care that you think I'm unsafe. I don't want to do it. Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. So they weren't using his real name. So where was the threat? If they weren't using his real name and he was John Doe number 5 in the jail, nobody knew who he was. The next day, October 27th, Kathy Allen hired Brett Gibson to represent Mr. Allen. We already went over that, and I've already showed you that. So this is just going over basically what her affidavit said, that she paid Mr. Gibson the $5,000. So Mr. Gibson contacted Mr. McClellan by email, which Mr. McClellan called Mr. Gibson on his cell phone. Mr. McClellan told Mr. Gibson that Mr. Allen was listed at the jail under a different name or an alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's department took him to a meeting room. Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. I don't think he listened. Otherwise, they wouldn't have recorded phone calls of him telling his wife and his mom and anybody else that would listen after months of confinement that he unalived Abby and Libby. So, Mr. Gibson, I don't think he took your advice. Even though Mr. McClellan and Sheriff Lesenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of, you know what? And Judge Diener held the initial hearing. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll County Circuit Court. The letter and the envelope are part of the record in this case. In the letter, Mr. Allen requests that the court appoint counsel for him. We've seen that before. Nothing in that letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll County Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in this court on November 9th, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the courts as of November 1st, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in Houston versus Lack of 1998, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. Lawrence versus State, 2009. The safekeeping proceedings was plainly illegal from the start to finish. First, Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make the safekeeping request on November 3, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff, statutorily authorized to make a safekeeping request. Because Sheriff Lesenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. And then gives other stuff. So I can understand what they're saying here. Like, was it illegal? Because I don't see that they would have had the, even if he was still in Carroll County, right? You had no threats against him. You just didn't want to deal with it. But you had no threats against him to request a safekeeping anyway. And then he's transferred to White County. So now you have no say-so at all. But yet you still filed for a safekeeping order. Just not getting where, if they would have had a legitimate threat or something against him, I could have understood it. But they didn't. Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue the safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Lesenby draft his safekeeping request in violation of Rule 3.1 of the Code of Judicial Conduct. That Rule 3.1 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9 of the Code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. Having violated both Rules 3.1 and 2.9, Judge Diener was obligated under Rule 2.1 of the Code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd, Bell v. State. Sheriff Lesenby's November 3rd, 2022 request by the Sheriff of Carroll County, Indiana to transfer an inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached to Indiana Code. Requires safekeeping requests to be made by motion. Requires that the Sheriff Lesenby's motion for safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his notice for safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was required to then serve Mr. Allen personally. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make a factual finding required by Indiana Code that would authorize the safekeeping order. Fifth, because the factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Lesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only the defendant's personal safety, a defendant may refuse the transfer. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. So, I mean, I'm not a lawyer, but that's the way I look at it. They violated his rights. And I hate saying that because I think either he did it or he had something to do with it, right? So I hate to say, like, I feel like they violated his rights, but I've said it from the beginning. Them keeping him in prison for his own safety didn't seem right from the beginning. I've said that. Maybe I'm wrong. I'm not a lawyer. So, Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of legal skullduggery that would land him in solitary confinement at the Westville Control Unit. Is this like a legal term, skullduggery? I don't know that I've ever heard that word. I'm not sure that's a legal term. Wabash Valley Correctional Facility and Cass County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standard as trained lawyers. One consequence of this would be that the Sixth Amendment and Article 1 of Indiana Constitution should apply when pro se litigant is excluded from proceeding at which he or she has the right to be present and participate in. And my understanding, I might be wrong, I'm not a lawyer again, but my understanding is when you are charged in Indiana or any state, you have the right to be at every court hearing. Doesn't matter if it's 5 minutes, doesn't matter if it's an hour or the full day. You have the right to be at your hearing. You have the right to be at anything that goes on with your court, you or your attorney. So, if Mr. Gibson wasn't representing him anymore, then Richard Allen should have been there. But remember, Gull said she didn't want him in her chambers because she didn't trust him? That seems like a violation to me. At least his lawyers were there, though. I feel like they violated his rights there. I'm not a lawyer, but that's how I feel. And I hate to say that because I hate to take up for him. It is a violation of the Sixth Amendment to completely deprive the defendant of counsel at any critical stage of the criminal prosecution. We're not going to say what I almost said there. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had the Sixth Amendment right to have his lawyers interpose all the objections to the November 3rd safekeeping order set above. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel. So then they just go into more blah blah. Then they're saying that they violated his. There's just more. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. In either case, accordingly, the court should vacate Mr. Allen's convictions or set the motion for hearing. Probably not going to happen. It's Gull. She don't like you. Doubt she's going to do that. In violation of the Due Process Clause of the 14th Amendment, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing the testimony was false before it was elicited or failing to correct it once it had been elicited. So then they just go into how essentially Brad Weber said he got home at 2:30. They say he got home around 2:30. They're just trying to say that they got Brad Weber to say something that wasn't true. Because he didn't say, I got home at 2:45. or I got home at 3 o'clock. He said around 2:30. About 2:30. Well, about 2:30 for me would be anywhere between 2 and 3. Give or take. Half hour. So I don't find this one as important. What I do find important about this is that at trial, the undisputed evidence was that Libby's cell phone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25. It then started moving again and stopped moving permanently at 2:32. In closing argument, Mr. McClellan called it a hard fact that Libby's phone stopped moving at 2:32. Well, that may be. But they're saying here, because he didn't get home, Brad Weber, until 2:44, that Richard Allen couldn't have seen his white van. Therefore, basically his confession and all of that should be thrown out, essentially, is the way I take it. Again, I'm not a lawyer. I'll zoom in on this if you guys want to read it. I'll scroll down and stuff, but I need a break from reading, so give me just a minute. Okay. So, right here is one of the stills that they took. And right here you can see the van. Here's the windows, the side windows. Here's the back window, right, of the van. So they like really went into the exhibits on this one, 3A, B, and C of the video. They really went through this and just kept going on about it. But they keep saying that other files produced by the security camera in the state's possession provided to the defense in discovery. You can't say, right here, state's possession provided to the defense in discovery. You cannot say then that it's new evidence, newly discovered evidence. It's not newly discovered. You've had it since discovery. And then you had 2 years almost to look at it and decide. And when Brad Weber was on the stand, why didn't you say, well, Mr. Weber, you say you arrived home at this time, but this is what the video shows, and then try to show it. Like, why didn't you pin him down on that? Like, it doesn't make any sense to me. Like, you had him on the stand. You could have asked him about it. Like, ineffective assistance of counsel, dude, because you didn't say jack. You just let it go. And then you want to file this. Well, why didn't you show it to court? Why didn't you show it at court? Why didn't you show it in front of the jury and let the jury see it? Would the jury have decided otherwise? Just like the Ron Logan stuff. You had it. I get you couldn't bring it in because no third-party evidence, right? I get that. But the second that doctor said a box cutter was used, that should have opened the door for you to go back to the judge and say, oh, we need a break, judge. We need to talk to you outside of the jury. We need to discuss this and bring it up again, because then it would have been on record of her denying, even though there was a nexus and you could put it together now because there was a box cutter and he knew all this information. Like, why? Were they not thinking? Did they forget about it? Did they not think it was important? Were they holding it in their back pocket just so they could bring it up? And like, I don't understand what they were doing. Like, to me, that would have been something that I brought up in court. You want to say that the prosecution didn't correct him while he was on the stand. Well, neither did you. Neither did you, defense. And you could have. It was in your possession. You said it was in discovery. So you had it. You could have pulled it up. You could have asked for a recess. If the prosecution can ask for a recess, go outside in the rotunda and Google something and come back into the courtroom, right? And put that expert opinion, that expert Google opinion, I guess, on the record. Then why? Why couldn't you bring this up? This wasn't third-party evidence. This wasn't saying, well, Brad Weber did it. This would have been you blowing up the state's timeline. This would have been you proving Brad Weber as a liar, right? So why didn't you do it? I'm not a lawyer. Maybe I just don't understand it. I don't know. But to me, I feel like defense should have brought this up. Don't leave it to the prosecution. They're not going to bring it up. They ain't stupid. They want to convict your client. And if what Brad Weber says helps convict your client because it matches their timeline, they're not going to correct him. Is that misconduct? I don't know, but I don't know. It might be. But they're not going to correct him. You should have. You got a problem with it, so you should have corrected it. So, again, they went on and on about this video that they didn't bring up either, which I don't understand. So they just kept going on and on about this and talking about. So then they finally say that Mr. Allen should receive a new trial. The defendant must show, one, that there was false testimony. But was it really false? Right? So to get a new trial, this is what he would have to do, is prove that there was false testimony. But there wasn't really false testimony. He said about 2:30. Well, about means different things to different people. To me, that's 30 minutes, give or take. I'll be there in about 30 minutes. I might be there in 10. I might be there in an hour. About. He didn't say it was definitely 2:30, right? He said about. So 2, that the government knew or should have known it was false. Again, about means different things to different people. So you're going to have to prove what about means. I don't see that they're going to say anything about this because he said about. Like, this is wordplay for me. They're trying to take and twist everything. And they want basically the prosecution. Well, prosecution said 2:30. That's false. It was 2:44. We're talking 14 minutes, right? Less than 15 minutes. So even if somebody's about is 15 minutes, give or take, he's still within that 15 minutes. So 1 and 2, I don't think have any say so here. So 3, that there is a likelihood that the false testimony affected the judgment of the jury. That would be the only one I would see that they could possibly stand on, because I watched the jury. Like, that's what I did when I went into the court. I watched the jury, and I don't know if it would have affected them, but if I'm sitting on a jury and I have a state telling me this is a hard timeline, this is exactly what happened, and this is exactly when it happened, and then the defense can blow up that timeline, it's going to make me think, well, they just blew up your timeline, so how much do I trust what you're telling me now? So it says there is a likelihood that the false testimony affected the judgment of the jury. And I think there is a likelihood of that, because if they could have blown up the state's timeline, it might have made the jury second guess. I still think the jury would have come back guilty, though, because they think Richard Allen was bridge guy based on what he was wearing in his own timeline, and that's literally all the state had to prove, okay? The state didn't have to prove that Richard Allen, by his own hand, took Abby and Libby's life. They only had to prove that he is the one who took them off the bridge, resulting in their death. That is all they had to prove. And I think they proved that. So I don't know if it would have affected the jury. I don't know. So to obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw the white van. And I guess, yes, they did, but that wasn't the state's only piece of evidence, okay? That wasn't, if you go to Murder Sheets and you listen to their podcast, it's a 2-part series. They spoke to one of the jurors. She was a younger lady that sat on the jury, and she talked about the deliberations and what they went through. And she specifically talks about Dr. Walla and how much emphasis they put into that. But one of her biggest things that she said that stuck out to me is, if it wasn't Richard Allen, who was it? Right? Because they agreed that Richard Allen put himself on the bridge wearing the same clothes. So would it have had an effect on the jury? I don't know. Would it have just made deliberations go longer? Possibly. Would it have made a hung jury? I don't know. That's not a question I can answer. But I think that out of those 3, that there's a likelihood that the testimony affected the judgment of the jury is the only one they have to stand on there. So that's just more about the stinking van. Okay, I'm so tired of hearing about the van. Okay, so let's get into this. Ron Logan, the confession to Ricky Davis, right? Before May 15th, 2017, is newly discovered evidence entitling Mr. Allen to a new trial. Again, I said it a while ago. It's not newly discovered if you had it in discovery from day one, right? Like, I don't see where they're getting newly discovered, except for the fact that the word box cutter was used by the doctor who performed the autopsies, right? If it wouldn't have been for the word box cutter, you wouldn't be saying new evidence, because that's what you're trying to say now. So again, you should have, could they not? I don't know. I'm not an attorney, but could they not have said, "Oh, judge, hold on, stop. We need to talk to you outside the presence of the jury. We need to discuss this." Because this had not been said prior. And he got this epiphany while he was in his garage or at his workbench, right? So it wasn't in any of his other testimony. And then it would have been on the record. And then when they would have brought all this up, it would have been on the record, Judge Galt denying them, right? Judge Galt denying the third party. I think that she would have denied it. I think she would have been wrong at that point if she would have denied it, but it still would have been on the record, right? So again, it's not newly discovered evidence if you've had it since discovery, right? Dr. Kaur was the forensic pathologist who conducted the autopsies of Libby and Abby. His original opinion, held for years, about how Libby and Abby died was that two weapons were used, a serrated blade and a straight edge blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Kaur opined that the girls could have been killed by a single box cutter rather than two different knives. Again, at that point, I would have said, Your Honor, we need to have a discussion outside the presence of the jury. Jury would have been sent out. You could have talked to the judge then. Why didn't you? Exhibit 4A, as attested to by Matthew Hoffman, is the defendant's Exhibit 4 is a redacted copy of the tip from the Orion database of tips dated May 15th, 2017. So we read over that. And that's where, the lady called. He didn't want anything for it. He just wanted justice for the girls. Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15th, 2017. So again, the girls were killed on February 13th, right? By May 15th, you have somebody coming forward and saying it was Ron Logan. He told me XYZ, and that matches your crime scene. We know now, those of us that were in court, or those of us who have watched the lawyers or the other people, the YouTubers that have been in court, that confession from Ron Logan, if it's a legit confession, not like we can find out now because he's dead. Shucks. So it's not like you can cross-examine him at this point, right? Is it hearsay? You've got Ricky Davis telling you what somebody else told him, right? So is that not hearsay? Again, I'm not an attorney, but to me, that seems like it would be hearsay. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, reproduced below. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters, struggled with one of the girls, and thought drops of blood from his nose ended up on their clothes. Ricky also advised that he killed the older girl first. Okay, so If blood fell from his nose, right, onto the clothes, we know that they left the quote unquote F tree. We know that they left the sticks. They went back later and got those. Like, they screwed up this investigation. Let's just say it honestly. They screwed it up, right? They did not take things. Livy, or I think it was Livy, it might have been Abby, had a hair wrapped in her hand, right? Entangled in her fingers. And they didn't think to DNA test that for 7 years. They DNA tested it and got the results while they were in court. Like, you couldn't drop the ball any further if you tried at this point. They really screwed it up. They did not do what was right by Abby and Libby by any means. And Abby and Libby deserve justice. They deserve true justice. And if that means that Richard Allen didn't do it and that Ron Logan did, as much as I hate to say it, because I still feel like Richard Allen had a part in it, it's not true justice for Abby and Libby if the wrong person is sitting in jail. I know that we can't put Logan in jail because he's dead, right? He will get his when he met his maker, right? You can't hide that from God. But again, Abby and Libby deserve justice, right? Abby and Libby deserve for the truth to be out there. And the only reason I feel like Richard Allen had something to do with it is because Libby had the guts enough to open up her phone and record the man on the bridge coming towards them. Right? That is what Libby did. And that is what I think when I think of who could have done this, is Libby in her last terrified moments recording the man coming at them. And that tells me that's the man that did it. And I believe that man to be Richard Allen. But it does give me pause that within 3 months of the murders, right? And within 3 months of these girls being killed, there is somebody else whose property they were found on who could have, because let's say the FBI thought it was him at first, right? They got a search warrant for his house, for his property. Like, it gives me pause that within 3 months before the public knew, right? The public didn't even know that the girls' throats were cut, that an artery was hit, right? The public didn't know that. But Ron Logan knew it enough to tell somebody else who turned him in. That gives me pause. That makes me sit back and go, did I have it wrong? Do I have it wrong? Is it possible that he didn't do it? It makes me wonder. And it's not just because the defense is saying it, because quite frankly, I don't believe the defense or the prosecution in this case. But there was a tip that came in, just the same as Richard Allen saying, hey, I was there that day. I was wearing blue jacket, jeans, something on my head. I was on the bridge. Turned himself in, right? Voluntarily. So I have to look at Ron Logan the same way. Within 3 months, he's giving details to somebody that nobody should have known except for the killer. And in the footnote here, it says, Mr. Allen also said that he shot the girls in the back, buried them in a shallow grave. Neither of the girls were buried. Neither of the girls were shot. But yet Ron Logan said that he cut their necks. Ron Logan said he hit an artery. Things that only the killer would know 3 months after the girls were killed. And this is about Abby and Libby. This is about justice for Abby and Libby. There's been a conviction, but it's not true justice if it's the wrong person. So anyway, rant over. Let's move on. Ron Logan's confessions to Ricky Davis, as reflected in the tip in the Orion database, are made a mere 3 months after the girls were killed. And detailed. Law enforcement followed up on the tip, but did they? I mean, think about it. Did they? They didn't follow up on Richard Allen. So did they follow up on Ron Logan? Like, this investigation has made me double think what law enforcement would normally do. Things that I would think that they didn't do in this case. And that makes me go, did they do it in the next case? Defendant's Exhibit 4B, as attested to by Matthew Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant Mr. Hansard about his interview with Ricky Davis on June 21st, 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective N. Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Ricky Davis about Ron Logan's confession provide even more detail. And I will do my best to tell you what I think these say. As hard as they are to decipher and subject to debate and correction, those notes revealed the following about Ron Logan's confession to Ricky Davis. Part 1 of Exhibit 4B is reproduced below. Walking, talking about knowing one of their dads. I can't tell what this word here is. Walk with him. One of mom's one of them wanted to turn around, grabbed youngest shoulder. It's okay. Oldest freaked out, got panicked, and grabbed her. One said something about calling police. SA wasn't true originally. Not trying to go R them. Paranoid about probation. Felt like he crossed line when he grabbed youngest one. So let's see what they say it says. Walking, talking about knowing one of their dads, to walk with them, so they weren't able to make out this word either. One of them wanted to turn around, grabbed youngest shoulder. It's okay. Oldest freaked out. One said something about calling police. SA wasn't true originally. Not trying to go R them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. So, sounds like we got that one about right. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. Oh, okay. He started talking. Ironic, should have been in school. Talking to them, knew one of their moms worked at a bar. Animals, walked with them, willing to go check out horses, and he states maybe or says he told them he had rabbits in barn, walk through trail in woods, oldest paranoid, don't want to go, youngest wanted to see horses. It seems to say he started talking. Ironic, they should have been in school. Knew one of their mom waitress at a bar. So that to me looks like worked, but I guess it could be waitress at a bar. Animals walked with them, willing to go check out horses, and this XXX, I'm assuming is this word right here. He told them he had rabbits in the barn, walked through trail in the woods. Oldest paranoid, didn't want to go. Youngest wanted to see horses. And I would be curious to know if Abby liked horses. I mean, she's the youngest. Did either of the girls like horses and rabbits? I mean, is that something that she would normally do if she's seen horses? Would she want to go look at them? Would she want to go pet them? Like, that's clearly verifiable through the family. Like, if this would make sense. So the top half of page 3, exhibit 4, reproduced below. Oldest tried to help youngest, maybe. Oldest started looking, maybe. Youngest scared. I can't tell what this word here is. I say that's SW. I don't know. I can't tell. He now grabs oldest. He said, he got hit on nose, scared. He got blood. One of the girls, I'm going to assume that's the. It looks like me, but I'm going to assume it's the in that situation. Pulled box cutter out, slit oldest one, hit an artery. Again, that is something only the killer would know. Only the killer knew that at that time. Youngest, scared, etc. Took little girl with him for a while, never said where. He said he cut her to cut both necks. Again, only the killer would know that. Because at this time, when this is being said, the general public did not know this information. I mean, sure, there was talk out there that that's what happened, but nobody knew for sure. None of the public knew for sure anyway. Oldest turned to help youngest. Yeah, that might say turned. Oldest started looking or kicking. I say looking. Because notice the K's, right? And this just goes up and down, whereas the K kind of does that. So I'm going to say looking. Youngest seemed. I don't. So that would be youngest. They say this is seemed. I don't know about that one. He now grabs oldest. He said he got hit in the nose, scared he got blood on one of the girls, pulled box cutter out and slit oldest one, hit an artery. Youngest scared, etc. Took girl with him for a while, never said where. He said he cut her neck to cut both necks. So it looks like I'm going with looking on this one, and I don't know about seemed. Um, I don't know. Youngest something. I can't tell. I don't know. I still want to say. I still want to say scared. So bottom half again. He left again. Came back. Uh, in evening. Search going on. I don't know about this. We'll have to look at the bottom. I can't make that out. Something oldest one, two, new, not going to be kind. We'll have to look at the bottom for this one. Place where four-wheelers something go. Burned his clothes in burn pile. Hiking boots, gloves, bag. Okay, so we've said that the girls didn't have they they didn't bring DNA, right? Into trial. So is that why there was no DNA? Because he wore gloves? Is that why his DNA was not on the girls? Because Richard Allen didn't say he had gloves on that day. So let's see what they say it says. He left again, came back later in the evening. He left again, came. Yeah, I guess that could say back. I don't know that that right there says later, though. I don't know. I can't read that one. In the evening. Search going on. Later on, late hours. Search going on. Later on, late hours. Yeah, that would fit. Tried. Maybe. Tried to move oldest one to. They say oldest one to area not going to be found. Oldest one to blank. Yeah, I guess that could say area. Move oldest one to area not going to be found. Place where four-wheelers something go. Burn his clothes in the burn pile. I got that one. I'm going to say hiking boots, not walking. That looks like an age. Hiking boots, gloves, and bag. So what was the bag for? What was in the bag? Like, are they going to tell us what was in the bag? I guess not, because probably not anyway. Okay, so the top half, okay. So, could soles be, no, wait a minute. Could soles of boots be located, maybe, in burn pile? Next morning, two other girls knocked, maybe, on door, ask to search on property, feel weird if he said no. He let them something off, got a hold of family member, and got out of area. So this one says soles of boots be blank in burn pile. I say located. 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 That's how I look at that. So I'm going to say located in burn pile. Next morning, two other girls knocked on door, asked to search on property. Feel weird if he said no. So they got knocked too. He let them take off. Oh, because the guy's K's. Let me find a K here. Of course, there's not one. Well, I guess if that's a knocked, but that's just using context clues there for that one. So maybe take off, but T A K E. Yeah, maybe take off. Got a whole family member and got out of area. Okay, so far I'm reading the same thing that the defense is writing here. Years of reading Dr. Handwriting is coming in handy here. First time he seen them from I don't know what that word is. I don't know. Something guns, etc. Drawing struggle, youngest girl. Something not something. I want to say scared S C, or it could be SEEMED. We'll have to see what they say on that one. I know that's not. I can read that. These two words I'm not sure of. Okay, I can't read this one. So first time he seen them from property? First time he seen them from... Does that look like property? Does anybody else see property in that? Perty. Maybe. Maybe. Home, blank, blank, etc. Guns, etc. So they're saying this is home. So I can see that. See, I think this says under or in under or enter. See, UNTER. I see the etc. guns, etc. And I guess that could be home. Maybe. Drain struggle, youngest girl, blank, not blank. So they couldn't make out those two words either. Happen to friend, blank, to stand there. Happened to friend continued. CONINUED. So continue. Happened to friend continued to stand there. So he killed one and the other one continued to stand there, maybe? Head, neck, artery. Head, something, neck. This doesn't, to me, this doesn't say artery. I mean, I guess this is a Y. I mean, we can make out the Y. So maybe. I don't know. What do you guys think? So that I already read. So this is just going over it. What we already read about that. Defendants Exhibit 5, the affidavit of Stacey Eldridge, states that dirt or water damage to the phone could not have caused the auxiliary jack on Libby's phone to log wired headphones plugged in and wired headphones unplugged. Ms. Eldridge's expert opinion is newly discovered evidence that would possibly produce a different result in a new trial. I see why they're saying that, right? Like, they say that because at trial it was Googled, but, or asked, but I don't know. I just don't think that the phone was wet, and here's why. Nothing in the data on Libby's phone indicated there had been water damage. None of the reports or extractions related to Libby's phone created by law enforcement officers reflect dirt or water damage to the phone. Photographs of the phone taken by the Indiana State Police did not show the phone to be wet, dirty, or covered by debris. Ms. Eldridge is unaware of any scientific or technological research suggesting that water or dirt damage to the iPhone 6S would cause the phone to inaccurately log wired headphones in or wired headphones out. I mean, I got an iPhone 6S. I can go test that, but I'm not going to. Partly because I don't know how to get the pictures off of it. So according to the Apple Health data on Libby's phone, the phone stopped moving at 2:32 p.m. on February 13th, 2017. At trial, the state contended that Libby and Abby died close to that time, and Abby hid the phone under her body before she died. So we know they crossed the creek, right? So unless they held, which came up to a certain part on their body. So unless they held the phone up, or they put the phone in their bras, or something of that nature, right? If they would have put it in their pocket, I would have thought their pockets were wet, from what I understood. So, like, I don't know. Could it be water damage? Yeah, I'm sure it could be, but you've got to prove it. You can't just say, oh, it had water damage. Well, did the phone show water damage? Clearly it didn't. No. Clearly it didn't. Because they say so. And there would have been evidence. I think they would have logged that. I mean, surely they would have logged that there was water damage if there was truly water damage to the phone. So, if Mrs. Elder's actual expert opinion that wired headphones were plugged into Libby's auxiliary jack at 5:44, which is what they said, and unplugged almost 5 hours later, were credited by the jury, the state's narrative is impossible because remember they said once he was seen, once he left, he never came back. They basically agreed to that. So they're saying if it really was a headphone being plugged in and unplugged, then it couldn't have been Richard Allen. So I think they're kind of just going over what they went over in trial in this one. So I don't know. The foregoing reasons, Mr. Allen respectfully requests the court to either vacate his convictions or set matters for a hearing. I don't think Gull's going to do that. And it is Gull that makes the decision on this. And I don't think Gull's going to do that. And this is just saying that under penalty of perjury that everything they said is true. So this is the motion to preserve specific evidence. Just skip through some of this. Richard Allen's attorney's request for the following specific evidence to be preserved. All physical evidence from the crime scene or near the crime scene, including any belts, cigarette butts, or any electronic items, whether or not they were working. All DNA swabs taken during the investigation or even during the trial or afterwards. And this, I would think, would be normal to file this motion to preserve evidence. That way they don't say, okay, well, we got a conviction. Let's go ahead and destroy the evidence, right? Because if he gets a new trial, if he wins the appeal and gets a new trial, if he wins the appeal at all, like that evidence should not be destroyed until he's out of appeals. So in my opinion, I'm not an attorney. So I would think that this would be a normal filing to preserve the evidence until this case is gone through the appeals or whatever. All forensic evidence obtained during the investigation or even during the trial or afterwards. Any and all reports or lists that identify anyone whose interviews were erased while in possession of law enforcement or the state of Indiana. All evidence identified on the state of Indiana's exhibit list or that may be exculpatory in nature. The items identified in 1 through 5 are not intended as an exhaustive list of items that the defense is requesting this court to order preserved, but rather are a few of the specific items that the defense is requesting following this court's previous denial of the defense's request to preserve evidence for lacking specificity. The state of Indiana has a continued obligation to preserve any evidence that may be exculpatory in nature. Wherefore, Richard Allen requests this court to order the state of Indiana preserve this evidence detailed within. or herein, which, like I said, I would think that this would be a normal filing to do. Again, not an attorney. I don't know, but I would assume that this would be normal. So this is Ron Logan. This is his basically intake, his mugshot. That's the word I'm looking for, right? This is his mugshot when they arrested him for the parole violation. I don't see any swelling, right? Like, supposedly he got hit in the nose, right? I don't see any swelling. But I'll point out what I do see. And I don't know if this is the way they took the photo, or if this is shadows, or what. But I'm going to point out what I see, and you tell me what you see. Right here, looks like there could be a little bit. Okay, so this is dark, right? This looks like a shadow. This right here, and I don't know if you can see it on the screen. It looks more like a bluish gray, right? Maybe it's just the shadow. I don't know. What do you guys think? Do you think it looks like he's been in an altercation? Okay, so now I want to show you the still photos of the white van. And if I can go to it, I'll show you the actual video of it. So this is 3C. This is level 1, level 2, and level 3, I believe. Maybe these are, oh, no, these are all level 1. Sorry. So the red circle here is the white van. Let me zoom in, see if that, like, I don't see it in this. I will say that. I don't see it, right? I know they're saying it's there. And I guess I can kind of see it here. But I can say I did see it in the video. Like, you could see it in the video. So, remember how they said it was 12 hours off, right? So, this is a still shot from the video. The date says February 13th, 2017 at 2:44 in the afternoon. Right? But they said it was 12 hours off, whereas 12 o'clock would be 12 p.m. would be like 12 a.m. or whatever. Like, it was 12 hours off, right? So this should be, what, 2:44 a.m.? Or did they correct the time? Like, that doesn't make any sense to me. You say it's 12 hours off, but you show the same time here. So this is, and I will say I can clearly see it in this. This is Zoom level 2 from Exhibit 3B. This is from the video. You can clearly see the back of the van there, the windows. I can somewhat see the van there, not really as much, but you can definitely see the van there. Window, window, window. Like, you can see the van, but now notice this one doesn't have the timestamps. So maybe, well, I guess it wouldn't because they zoomed in. So this is the level 3 zoom from 3B. You can clearly see the van. Although I will say the back of the van, you can tell it's a white van. Okay, when it's the video, which I'll try to pull up, you can tell it's a white van. Although I will say in this one, I had to look at it for a second because that looked like the back of a school bus for a minute. But you can tell. Again, right here, I really have trouble seeing it right here. But you have no trouble seeing it there. Front of the van, passenger window, doors, back window, back of the van, right? Like you can clearly see it. So let me, if I can find my mouse here. Okay. So let me see here. Let me see if I can share my screen here. Maybe eventually. Okay. Let me. Add to stage. Okay. So this is the video. So right here, let me just go bigger here. Right here, you see the van. See it? Yeah. Let me replay it. You can see it right there. And then you're going to see it go behind this post. And you're going to see it emerge again here in just a second. Right there. So you can see that it's a white van. It's right there. Right there. So that's one video. Now, it shows you it's a little more zoomed in here. Or, well, they may have, yeah, they zoomed it. And there it goes. So that's the videos of where they got let me see if I can. I don't know what I'm doing. Okay. So that's the videos that they got these from, right? And again, you can tell. Right there's the white van. We just watched it go by. Now, I will say in the description of this video is where I got all of these court documents and these videos. And I had debated on going over these at all. I did. I wasn't sure what I was going to do. But again, this is about Abby and Libby. And they deserve justice, right? We all agree on that. And whether or not we think Richard Allen did it, or we think Ron Logan did it, the girls deserve the right person to be in prison, even though Ron Logan is dead. Like, you know what I mean? Like, does it change your mind? Because for me, Richard Allen admitted to being on the bridge, right? Richard Allen was the man in the video. Richard Allen is bridge guy to me. Because for Ron Logan to be bridge guy, right? Ron Logan would have had to walk across that bridge, then back behind the girls, then to his property. Okay? So for me, that doesn't make any sense. Because I don't think he would walk across just to come back over. I don't see that. Like, it doesn't make any sense to me for Ron Logan to walk across the bridge to come back over. That doesn't make any sense to me. So Ron Logan to me is not bridge guy. Richard Allen is, because that's what Richard Allen said he was wearing, right? So I want to show you this. This is a different picture. It's the same picture. It's just not as bright as this is Ron Logan. Everybody that knows this case knows that. This is the same picture. This is when he was arrested on the probation violation and was sent to the jail, right? So for me, I don't see, like, it still looks like it's a little bruised right there for me. Not over here, right? But this looks like it's a little bit of a more yellowish green shade. Could it be lighting? Maybe. But anyway, I don't know if any of this information would have changed a juror's mind. But if the jurors didn't get to hear it, right? And they didn't get to hear it because Judge Gull said no third-party evidence. Okay, no third-party evidence. Why? She said no third-party evidence because there was no nexus. But if Ron Logan is confessing to somebody and saying these things, allegedly, 3 months after the girls were killed, right? And everything in there matches the crime scene, right? Then to me, that's a nexus, right? So I don't know. For me, I think that they could have got around the third party, no third party nexus, as soon as they said box cutter, right? But his defense didn't bring it up. So is that ineffective assistance of counsel? Can he have an appeal based on the fact that his attorneys didn't bring it up? And I would say yes, but I'm not an attorney. So we'll see how this plays out. Either way, right now, Richard Allen, I think you're guilty as sin. You've been convicted by a jury. And may you rot in there unless it's proven otherwise. And Ron Logan, if you did it when you met your maker, you had to pay for it. Because Abby and Libby, they deserve justice. And no matter what you think or feel about this case, they are what matters, right? These two beautiful young girls who had their lives taken way too soon are what matter. And getting them justice is what matters. And I hope that they have it, that they've gotten it, and that it sticks. So let me know in the comments down below whether or not you think any of this information would have changed a jury's mind. It would have gave me pause, but I think I still would have come up with guilty because all they had to prove was Richard Allen was bridge guy. That's all they had to prove. And he admitted he was on the bridge and the clothes that bridge guy was wearing. So to me, he's bridge guy, and that's all they had to prove. Thus, I would still find him guilty. What about you? Everybody, have a good day.